This is the good news, the Lawful Good News Show. The Lawful Good News Show will get a name and a title sequence eventually, but there are constantly cases that I hear about that I bet you didn't hear about, or really understand, or whatever, know the significance of, and going on all the time. So I've been gathering them, and I would like to start bringing them to you. And so here's episode 1. Just starting off, this is a case that happened in 2021, but I want to bring it up. I want to bring it up because in Canada lately is a politician out in Alberta, and she's a firecracker and a new and popular premier of the province of Alberta has been making many headlines and challenging the WEF and federal policies from Ottawa, saying that Alberta will not be forced to comply with orders from Ottawa and things like this. But most recently, Danielle Smith threatens the CBC with legal action over Coots blockade stories. She's claiming that they published untrue allegations that she says she didn't do, allegations of dishonesty and some sort of collusion or communications that were inappropriate. And Premier Danielle Smith has written a letter to the CBC threatening to sue them if they do not retract and apologize. If they do not retract and apologize for their, what she calls, irresponsible reporting. And she gives a deadline of April 28th to respond. Publishing untrue comments about each other is known as libel. It's a popular thing to threaten to sue for defamation. I mean, it's published, it's there, you got the evidence, it's easy to prove. So we'll see we'll see what happens, and I'll be bringing you an update to that story. Now, another story I want to mention is a case from Manitoba from 2021, from a year and a half ago or so. And there was someone running for leadership of the Conservative Party of Manitoba, and it was a scandalous victory at the time. And the reason why I connect this story is that Shelley Glover would have been like the Danielle Smith of Manitoba. She was that fierce and family woman, conservative moral values fighter. She was. Her case at the time, total scandal. So I want to read you some highlights in the Manitoba Court of Queen's bench. Glover v. Progressive Party. So, okay, there's a great, this was covered on the CBC had a good radio show. You could Google it and find it, with Shelley Glover. And she gives her first-hand account of how the election day went down and how the counts happened. And how at first there was like a tentative count, and she realized she had more than half because she knew the number of total votes and knew how many she needed plus one to win. And when the number was first read, it was more than that. She thought, oh, she won. And then the boxes were taken out of the room, unsealed, and transported somewhere else, and then the official count was made, and it was ruled in favor of the opponent, Stephenson, who is the current premier of Manitoba. And when you research her, she goes right back to when she was a young woman. She was like one of those WEF young leaders or whatever they're called, and she went and worked in Ottawa and had an internship there or something like that earlier in her career. So she's a career politician, Stephenson. She was, oh, I forget what she was. I investigated her career on Wikipedia. She was something high up in Manitoba right before becoming premier. like Minister of Health or something. It was very shady. Very shady how Shelley Glover, the Danielle Smith of Manitoba, was lost out in her election efforts. Was concerning whether the October 30th, 2021 PC Party leadership election should be declared invalid due to irregularities and breaches of contract. Glover filed an application seeking a declaratory order from the court to declare election results invalid on the basis that the election was fraught with irregularities. The applicant needed to prove that the irregularities were more than significant and, quote, materially affected the election results, and that the PC Party Leadership Election Committee was in breach of its election contracts. And then I got into election contracts, and there's election committees, and it's kind of a select group, and oh my God, there's some member of parliament that selects who's on the committee, and just investigate for yourself, please. So there were a number of irregularities throughout the election process. Some of the irregularities were ruled as immaterially significant, or to have occurred in the open with no evidence of tampering having been submitted. It was crazy to read the language. Key irregularities were not considered because no sworn affidavit was filed as an exhibit. But it just, to me, when I read this case law, it stinks of crappy lawyering. It's just crappy lawyering. I mean, I could have done better. I tell you. It was, you read comments. Let me find some comments. Exhibit A, attached to the affidavit of Mr. Mazurkowicz, is a handwritten note prepared by Destiny Watt titled Destiny's Addition Sheet, which purports to record the results from the 18 counting tables on Election Day. This is what Shelley Glover was talking about on the radio. Although it is not clear which tables are being recorded, her addition sheets record 7,667 votes for the applicant, Shelley Glover, and either 7,170 or 7,380 votes for the intervener, that's Stephenson, and the PC Party. This document is hearsay evidence. And Ms. Watt did not swear or affirm an affidavit to prove her handwritten notes in this proceeding. What crappy lawyering. If that was part of everything that went down, I would have had Ms. Watt swear an affidavit, and I would have attached, it was attached as an exhibit, the tally sheet, but it gets counted as hearsay because she didn't affirm. Ridiculous. These are crucial things if we, the good people, are to take back our courts and restore actual justice to the world. Another issue that gets raised is that the voters list and spreadsheet that the election circus, apparently, there is a voters list on a spreadsheet that was delivered at 12:27 a.m. on October 30th. So basically the day before, at the very end of the day at night, so, 12:27 a.m., it is emailed to everybody, which provided a final tally of the members of the PC Party who had voted and whose ballots had been placed in the ballot boxes. The applicant and other viewers reviewed the voters list and spreadsheet and determined that it represented 16,045 ballots that had been cast in the election. Okay, in fact, the tally sheets and the final election result announced on October 30th was that 16,546 ballots had been counted, suggesting that an additional 501 ballots were counted, and that this is an irregularity which amounts to a breach of the contract documents. The voters list spreadsheet was not filed as an exhibit in this proceeding. What? For reasons that were not explained, the scrutineers and the PC party officials involved at Scarrow and Donald law firm that counted the boxes on the validation floor and at the resolution desk did not track the number of ballots that were deposited into each ballot box. There is also no evidence that any representative raised this as a concern during the verification process. Okay, so the evidence of both Mr. Cook and Mr. Mazurkiewicz is that in the afternoon of October 30th, the unsealed ballot boxes were removed from the counting floor. Mr. Findlay acknowledged that he did not seal the boxes when they were removed from the Victoria Inn and placed in the back of his motor vehicle, suggesting that an additional 501 ballots were counted. So, that's kind of enough. So anyways, it's ruled that the applicant has failed to establish on a balance of probabilities that the irregularities materially affected the election result. And so no remedy is required in this case. So, it's bad lawyering. Failed to prove the case. And it really seems like on the outskirts that cheating happened. Where was I? Glover didn't make it. Crucial evidence that might have influenced the outcome of the judgment was not submitted as evidence. Sketchy. And then immediately after, instead of appealing, Glover just conceded. So, I don't know. And Glover would have been like Daniel Smith in Canada. Okay, moving on. Another case that's not necessarily latest law news, but an older one relevant to what's going on right now. And from time to time, I will bring up older cases. It's important. Older news, older law cases that we need to know about that are relevant. Lots of us have probably heard of the Johnson & Johnson baby powder settlement. And it was ruled that they knew about it all along from the beginning and were grossly negligent. So what happened in a nutshell is the Johnson & Johnson company created a shell corporation, is it called? I learned this. A shell corporation, a separate one for the baby powder line. And then out of the settlement, then just that separate corporate entity bankrupted, and the Johnson & Johnson machine just carries on. This is essentially how we incorporate to get out of liability. The whole, turn yourself into a corporation and get out of liability kind of thing. So they created a shell company. They bankrupted that company and then carried on la-di-da. It might explain why Johnson & Johnson is now called Janssen or something. Like, did they have to do a name change? Which brings me to Alex Jones ordered to pay another $473 million to Sandy Hook families on top of the $1 billion ordered last month. Wow. Okay, so it's way up there. So through my paralegal course, I came to know this channel called Legal Eagle. And he's a lawyer and has a YouTube channel, and he comments on cases. And so he commented, one of them that came up recently was Alex Jones is now personally bankrupt. And so the Legal Eagle lawyer guy covered the Alex Jones case. Alex Jones is, hit with these punitive damages that are astronomically high, that he's filing for, how rich do you think Alex Jones and his empire is? So he files for bankruptcy. Apparently he files for Chapter 11, Subchapter 5 bankruptcy, which courts and amendments to laws of late have made it easier and easier to file this particular type of bankruptcy, and maybe take advantage of as the Legal Eagle lawyer puts it, a quick and dirty mom and pop bankruptcy. So Jones is filing for this bankruptcy, but meanwhile, he's kind of done what Johnson and Johnson has done. So we all know Jones has the show InfoWars. So InfoWars is owned by a corporate entity called Free Speech Systems. Okay. Free Speech Systems sells, product sales for InfoWars. Then there's a PQPR Holdings Limited LLC, which sells products for product sales for InfoWars. All the cannabis oil and deodorant and survival tools that Jones peddles through his show. So apparently a few months into the litigation with Sandy Hook, the PQPR Holdings suddenly sent a big huge bill over to Free Speech Systems, the owner of InfoWars, saying that they owed for all of the products that PQPR Holdings has been selling for InfoWars and for Free Speech Systems, and they billed a $53 million promissory note. And so you can see where I'm going with this, is that now InfoWars has a creditor, owes this PQPR Holdings $53 million. And so in the event of Free Speech Systems and Jones and InfoWars being held liable, well, and he goes bankrupt. In a bankruptcy, the creditors get paid out first. And so PQPR Holdings would see their $53 million bill satisfied before the parents of the victims of the Sandy Hook and all of that. But the punchline here is that the owner of PQPR Holdings is Jones and his parents, and the legal eagle lawyer says it's like hang on, let me get the quote so I don't say things and screw things up. This is kind of like Alex Jones claiming that his right pocket owes his left pocket. His right pocket being InfoWars and Free Speech Systems owes his left pocket the holdings, which just made up a bill. So of course the lawyers for the victims and the plaintiffs are trying to argue that the promissory note and the bill is invalid, so that the creditors don't get paid out first. I'll read you some more good law quotes. The lawyers for Sandy Hook victims are claiming that Jones's promissory note bill scheme is a classic bad faith filing to gain tactical advantage in the Sandy Hook lawsuit, using a, quote, novel and dangerous tactic that is abusive and undermines the integrity of the bankruptcy system. Yes, the bankruptcy system has integrity, you see. Bankruptcy is intended to protect honest but unfortunate debtors who are forced to subject themselves and their assets to the supervision of the court. So Jones has filed motions to keep his radio show and business running. He says, we're just going through bankruptcy and appeals for the next 2 years. It's just a thing we're doing and something we have to spend money on. Wow. All right. What else? Okay, amazingly, the news is we've all heard that Mr. Trump has been indicted for a crime. Oh my goodness. Do you know who else is being dragged into court? There is a huge lawsuit against Biden. Amazingly, actually. It's called Missouri versus Biden. And apparently it's about big tech censorship and how governments essentially threatened the owners of big tech. That if they did not censor and delete comments and posts that were not aligned with a certain narrative, if they did not go along with that, they would be fined, and, you know, there were threats made, and apparently there's all kinds of evidence, proof, and this lawsuit has moved to a point of having already had discovery, which is where you are allowed to request information from the defendants in order to get to the bottom, and in order to uncover all the information that's necessary to make a decision, to make a ruling, I guess, right? You can notice that the difference here is that Trump is up for a crime. He's indicted of a crime, a felony of bribery or something. Whereas this lawsuit, this is a lawsuit, a civil lawsuit for damages for the censorship thing. But maybe there are crimes that come out of it. Independent journalist Kim Iverson's recent video of interviewing this doctor, Aaron Kheriaty, who is part of the lawsuit, along with Dr. Jay Bhattacharya and Dr. Martin Kulldorff, Attorney General of Louisiana as well as Missouri, on board here. Amazing, amazing, amazing. In this case, they are presenting proof and evidence of information being censored as disinformation that was later proven to be true and is still true. Apparently there is a U.S. House committee, Senate committee, one of those things, having a hearing, an investigation, the hearing on the weaponization of the federal government. So it's great to see it's being investigated, the big tech censorship, even calling it a censorship industrial complex. What they've learned in the discovery already has been, quote, astonishing, staggering, and horrifying. And much more information will come out in trial. There is multiple proofs of government agents orchestrating elaborate plots, having endless meetings to discuss disinformation and censorship, telling big tech owners what can and cannot be said on matters of public importance. Threats have been discovered to company heads if they did not comply with the feds. So the lawsuit is suing for the disarming and dismantling of the government collusion and pressure to companies. The beginning and end of the industrial censorship complex, which they're claiming started in 2016. Probably it goes back way further. 11 federal agencies are named as defendants in this case, including the branch of government whose task it is to investigate these censorship breaches is named as a defendant and part of the problem. So it might need independent review. In fact, we are all kind of waking up to the fact that all of our regulatory and review agencies have been taken over and are being used to keep a problem instead of actually regulate for the highest good. And apparently, okay, so this is all coming to light thanks to the Twitter files. Thanks to Elon Musk for purchasing Twitter for $250 billion after people said he could never spend all of his money and the rest of his life. Well, apparently he's showing us wrong. And making the internal documents public. The journalist Kim Iverson said that she wants to see the YouTube files and the Facebook files. We've all been censored. I personally had a few videos censored on YouTube. One for saying the things that we were wearing over our faces don't work. The video is taken down. When I edited the video and removed the comment saying don't work, the video stayed up. Crazy. Anyway, and another video of mine where somebody I interviewed mentioned the medicine that I have that one, mentioned simply that, and the video was taken down. The censorship is real, and thank goodness. And so I'm glad to see this lawsuit. I honestly believe we are going to see many more lawsuits and investigations and public hearings and inquiries, including the National Citizens Inquiry into Canada's response to COVID-19 that is now touring Canada, will be in Winnipeg April 13th and 14th, this Thursday, Friday. Incredible. And it looks just like the Emergency Act invocation hearings that we just had, that ruled that it was legit, them invoking the Emergencies Act. Well, did you know that the ruling or whatever that we just had is actually being challenged? Yes, it is, by the Canadian Constitution Foundation as well as others. They were just in court this week filing and arguing a judicial review of the invocation of the Emergencies Act. One of the main arguments the CCF puts forward is that the Emergency Measures Act very, very narrowly defines the standards and conditions under which the Emergencies Act may be invoked. Very narrowly and specifically defines it, and the ruling, and the use of it, and the ruling agreeing with its use has been applied in a very, very broad sense. And not very strict and narrow standards. And so that's the main argument put forward. So there's a new judge. A judicial review has been made. And I listened to the CCF's day 1 in court summary, day 2, and day 3. Love her summaries. Love that they are, that the Canadian Constitution Foundation is out there and brought this case forward. The judge hearing this judicial review, he asked some great questions of the Crown/government, which was good, and said that he would take 6 months to deliver a decision. That he really wanted to be clear, to review all of the case law that has been submitted, and make a very clear and concise decision that has very little opportunity to be appealed. So apparently this isn't the end of it. There might even be an appeal of this as well. So I'll keep you informed of that, but just so you know, it's not over. Okay, back to the National Citizens Inquiry. Just like the Emergency Act with the black curtains, I'm going to summarize a few of the witnesses that have testified so far. Lawyer Michael Alexander. He has actually been representing nurses and doctors across Canada who have been defending themselves against charges of spreading misinformation and even harming the public by making comments contrary to the COVID-19 narrative. This lawyer has been defending doctors and nurses who've had their licenses suspended, defending their right to speak freely, defending against the regulatory colleges. There's Dr. Trozy, who was in emergency medicine since 1990, taught at universities, never promoted the injections, resigned, and started a show to spread truth and medical help. A nurse said that she said it was acknowledged that COVID-19 had a 99% survival rate, and she was seeing many patients come in that had a lot of fear, deep fear about that, and she knew that the media was spreading lies. She declined the vaccine injection. She was fired for, quote, putting patients at risk. Oh, terrible. Nurse who didn't want to get the injection waited as long as possible, 41 years old, 3 weeks after the injection, had a heart attack. another witness and victim admits that she did not know that it was a gene therapy, that it was more than just a vaccine. She was injured. She took the shot to protect others, and now she needs to be protected. More lawyers. And then this guy, I remember his video. You can see his shirt says #answers for Sean. I remember his video making the rounds online because he got quite emotional and angry. His son loved hockey and hated needles. Got the injection because it was suddenly required to play hockey that he loved, and the son died 4 or 5 days later. Yeah, he actually got emotional and broke down into tears in the National Citizens Inquiry. So that's what I want to say. That's it for episode 1. I honestly believe we're going to see lots more lawsuits and truth coming out and investigations. That 2023 is the year of truth, is the year of love is the law. Because love is the law. Do no harm is the law. Imagine living through the 1940s. Like, first there must have been, like, building up of hate and contempt for certain classes of people. Oh, they have germs. Oh, lock them up. You know, war happens. You hear news of the war all the time, stories of war. Then the war ends. And the truth about those concentration camps came out. And all the horrors. At some point, that truth came out. The bad actors were put on trial. That happened. And I think that's about right where we are right now. Is the truth is bursting at the seams, coming out. Love is the law. And I look forward to bringing these stories to your attention and to bearing witness to the awakening of the great human family.